Hi everyone, thank you for joining our webinar. My name is Alena Chernyknizhnaya. I'm a trademark counsel of IPR Group, and together with my colleague Nikolai Burak, who is also a trademark counsel of IPR Group, we would like to share with you the recent changes and recent developments as to the Ukrainian trademark legislation. We hope that provided information will help trademark practitioners as well as individual and corporate applicants to gain a better understanding as to the features of trademark registration procedure in Ukraine, and thus protects the rights for your trademarks more effectively. So let's start.
Thank you, Alena. So changes to the Ukrainian trademark law were adopted on the 16th of August 2020, and these changes were adopted with the goal of harmonization of the Ukrainian legislation with the European one. First of all, we would like to share with you one of the most significant changes to the Ukrainian trademark law from our point of view, and this is 3 months of the opposition period. This change gives opportunity for any third party to file opposition against pending trademark application within 3 months from the date of the publication of the application in the official bulletin. So as you see, this is the same as in the European practice. Before the changes came into force, the filed opposition conceded by the examination if it has been received not later than 5 days prior to the date of making a decision under the application. We also would like to note that previous provision of law is also applicable, but this applicable only for applications that were published before the 16th of August, while for the applications that were published in the official bulletin after 16th of August, the opposition period is only 3 months. Sorry. Therefore, if you are using any search or watch services and you revealed trademark application that might potentially infringe your client's rights for a trademark, and at the same time your client may be interested in filing opposition against this application, we recommend you to contact us for the estimation of the chances for success as soon as possible, because total time frame for the opposition filing significantly reduced from almost 18 months to only 3 months. The other change that were adopted into the Ukrainian trademark law is concerned with the letter of consent for the use and registration of the applied mark in Ukraine. If you don't mind, I will cite this provision from the Ukrainian trademark law for you. So, according to this provision, identical and confusingly similar marks may be registered as trademarks if there is a consent of the owner of the certificate of a previously registered trademark or the owner of another previously acquired right, and there is no possibility of misleading the consumers. So, colleagues, this provision means that even if the letter of consent was obtained from the owner of prior rights for identical and or confusingly similar mark, along with the response filing to the provisional refusal, it will be also necessary to provide a grounded explanation as to the differences of the goods and or services, targeted consumers, trade channels, and other arguments. And this explanation is provided with the goal, in order to convince the examination that the registration of the applied mark will not mislead the consumers as to the manufacturer and or provider of goods and or services. Moreover, I would like to mention that before the new changes came into force, it was also possible to provide the letter of consent and the said grounded explanation. However, it was considered as a supplement to arguments. As of now, acceptance of the letter of consent is provided by the national law, and the examination has to take it into consideration. And now I would like to hand over to my colleague Alena.
Thank you, Nikolai. We continue. The next change to the Ukrainian trademark legislation is related to the right to re-register a trademark. Article 22 of the amended law sounds as follows. Nobody, except the previous owner of the certificate, has the right to re-register trademark within 2 years after termination of the certificate in accordance with paragraphs 1 and 2 of Article 18 of this law, unless the owner of the certificate will grant consent to register trademark. First of all, we would like to note that the term for re-registration of a trademark was reduced from 3 to 2 years following its termination. Moreover, the subject provision also refers us to the Article 18 of the same law, according to which the right to re-register a trademark is given only for those marks whose owners didn't timely pay the renewal fee, and respectively, trademark registration was voluntarily abandoned or terminated. It also should be noted that in case any third party wishes to register identical mark before the expiration of this 2-year period, it would be required to obtain the letter of consent from the owner of the previous rights. The next and quite important change is related to the non-use grace period in Ukraine. Earlier, the law provided 3 years non-use grace period. However, 5-year non-use grace period was introduced by EU-Ukraine Association Agreement, which came into force on the 1st of September 2017. Now, the amended law explicitly provides 5 years non-use grace period for registered trademarks in Ukraine. As a last point, we would like to mention non-traditional trademarks. Finally, the possibility to register sound trademarks was implemented in the national legislation. Through this opportunity was earlier determined by the Singapore Treaty, of which Ukraine is a contracting party. So consequently, it reinforces the need to upgrade the technical capabilities of the UPTO's registers in order to include different types of non-traditional trademarks. As to the other types of non-traditional trademarks, such as smell, taste, etc., it should be noted that their registration is also allowed by national legislation. However, indeed, the registration would be possible as soon as the UPTO will have sufficient examination facilities and appropriate sufficient examination potential and appropriate storage facilities, which unfortunately are not well developed yet. So that was the main changes to the Ukrainian trademark law in Ukraine. We hope that provided information was useful for you, and if you have any questions, we would be pleased to answer them.
Yeah.
So we will.
You can send your questions to our chat. So let's check it out. We see that there are no any questions on our chat. So colleagues, if you will have further questions after finishing our webinar, you can always contact our trademark team via our email, trademark.branch@iprgroup.info, and we will be happy to answer all your requests and questions.
Yes, thank you once again for your attention, and have a nice day.
And have a great weekend too.